We thought contracts meant protection, clarity, security. That was our first mistake. When we moved into Maple Ridge Estates, Karen personally handed us the HOA welcome packet. Thick binder, tabs organized, highlighted sections. You'll appreciate how structured we are, she said with a confident smile. She had been HOA president for 5 years. Efficient, polished, always prepared. The contract looked professional, clear language, detailed clauses. Escalation procedures outlined neatly. We skimmed it, signed it, trusted it, because contracts feel official and official feels safe. The first issue came 6 months later, a letter citing landscape nonconformity. We checked the contract. Landscaping requirements were listed clearly. We were compliant. We emailed Karen attaching photos. She responded with a screenshot of an updated addendum. Addendum? We never received one. She claimed it was distributed digitally, buried in a mass email subject line labeled Community Update. Inside that email, a revised enforcement clause. Expanded authority for immediate corrective fines without preliminary warning. No vote mentioned, no meeting summary attached, just policy activated. The fine was $250. We paid it to avoid conflict. Then came another and another, each referencing contractual authority. We reread the contract more carefully, and that's when we noticed something subtle. A clause stating, the board may amend enforcement procedures as deemed necessary to preserve community standards. As deemed necessary. It sounded harmless, flexible, responsible, but flexibility without limits becomes leverage, and leverage in the wrong hands becomes control. The contract wasn't protecting us, it was protecting her. Karen began issuing citations under the amended enforcement authority. No warning letters, no grace periods, immediate fines, mailbox angle incorrect, window trim inconsistent, seasonal decor lingering beyond acceptable time frame. Each fine escalated faster than before, $150, $300, $600. Appeals were processed internally, by the board, led by Karen. We requested the voting record for the enforcement amendment. She replied, board discretion allows procedural updates without full community vote. Procedural updates, not structural. That distinction mattered because enforcement procedures determine financial consequences, which means financial exposure. Financial exposure requires transparency, but the contract wording blurred those lines, and most residents didn't challenge it. Why? Because contracts intimidate. Legal language discourages questioning. If it's written, it must be valid, right? Meanwhile, we started noticing something troubling. Residents who attended meetings and praised Karen publicly rarely received violations. Those who questioned did. The contract gave her cover, but the enforcement patterns gave her away. We began documenting dates, comparisons, screenshots of enforcement language, identical phrasing across different homes, different violations, same escalation timeline. It wasn't about compliance, it was about alignment. The contract wasn't broken, it was engineered, broad authority, minimal oversight, and buried discretion. And once you see how it works, you can't unsee it. We hired an attorney quietly. At first, he reviewed the enforcement clause carefully, then asked one question: where is the community ratification? We didn't know, neither did Karen, because there wasn't one. The original contract allowed amendments, but state HOA statutes required member notification and recorded quorum for enforcement changes affecting financial penalties. We requested meeting minutes approving enforcement expansion, quorum documentation, resident notification logs. Karen delayed, claimed records were archived, then she issued another fine. Failure to maintain cooperative communication. That phrase wasn't even in the original contract. It appeared only in the addendum, which had never been properly voted on. That's when neighbors started comparing contracts. Some had different versions, different dates, different clause numbering. The standardized contract wasn't standardized. It had evolved quietly, without formal approval. The attorney's words were blunt. If enforcement amendments weren't ratified properly, fines based on them are vulnerable. Vulnerable, which meant refundable, which meant liability. An emergency meeting was requested. Attendance tripled. For the first time, residents weren't debating lawn height. They were debating contract legitimacy. And when the side-by-side contract versions were projected onto the screen, Karen's composure slipped because the document we trusted wasn't stable. It was adjustable, at her discretion. The independent review confirmed it. Improper amendment adoption. Missing quorum records, failure to provide required notice, inconsistent contract versions distributed across residents, all fines issued under the expanded enforcement clause were voided, late fees reversed, pending liens withdrawn. But the humiliation wasn't financial, it was procedural. At the final meeting, residents stood calmly, not angry, informed. They amended the contract properly, clear limits added, mandatory community vote required for enforcement changes, transparent notification protocols implemented. Then came the vote to remove Karen. It wasn't dramatic, it wasn't emotional, it was decisive, because trust had been broken, not by rules, by manipulation of them. As she walked out, the binder she once handed us so confidently felt different. Not intimidating, not authoritative, just paper. Because contracts don't protect communities. Integrity does. We trusted HOA-Karen's contract. Big mistake. If you've ever signed something you later realized was structured against you, share your experience in the comments. Like, subscribe, and share. Because silence protects manipulation. Transparency protects communities.